Hello, everyone. Welcome to another episode of the Unisolve Question. I have a wonderful guest from the West Coast with me today, none other than the preeminent litigator, Ken McEwan. Hello, Ken.
Hi, poet. That's awfully nice of you to say. Too much.
Ken, you work at a law firm named McEwan Partners.
Yes.
I I I, I guess it's your name on the door, right?
Yeah, that it is.
Okay, that's great. So before we jump into your path and how your name landed on the door, how many years have you practiced law?
I think it's 37 now.
37 now. I want to talk about some other people that I interviewed on the show that are connected to you in some way. First of all, you're not the first BC guest. I admit that this show has a very strong Ontario bias, guilty as charged. But I did interview a couple of BC guests before. So one of whom was Shannon Salter, who was at the time chair of the Civil Resolutions Tribunal. Then she was deputy AG, and now I believe she's deputy minister to the premier. That was a few years ago that I interviewed her. That was a wonderful guest. Another person that I think you've heard of that I interviewed is Jonathan Lysis. And I am interested in exploring this connection because this connection is related to a case you did in Vancouver, if I'm not mistaken, involving um, corporate control and one of the largest corporations in Canada. So Jonathan Lysis of Lax O'Sullivan Lysis Gottlieb LLP was also a guest on the show. Now, you are connected to Jonathan because you and Jonathan did a case together, and the case was Edward Rogers, and Rogers Communications Inc. Can you talk about that case a little bit and how it came about that you and Jonathan Lysis worked on that case together? Jonathan is from Toronto, you're from Vancouver.
Yeah, we were, and when I say we, it was through Tories initially contacted. I've had some connections with Tories over the year, and my partner, Emily Kirkpatrick, worked at Tories for several years. So, in fact, we were told not very much that there was something going on, that we may need to be involved to one degree or another in litigation in Vancouver. Briefed on it a little bit. And then as the matter evolved, Jonathan came on doing other parts of the case as well. As you know, I'm sure it went on and there were competition issues and so forth with the Shaw merger. So we came on. I'd known Jonathan before, worked with Matt Gottlieb, his partner before, Terry and Terry O'Sullivan and Cliff Lax through other cases. But that's how that came to be. And we worked together on the quick hitting Vancouver litigation.
So, what was it like to argue one of the biggest shareholder or corporate control cases in recent history at the height of the pandemic in 2021? Tell me more about the details. Was it on Zoom? Was it in person? Was it in Vancouver? Did the team, Jonathan Crawford, Matt, did they travel from Toronto to Vancouver? How did it work?
It was in person. It was on a tight schedule, at least for Vancouver, a sort of commercial list type schedule, which we do pull off from time to time on cases that demand rapid solutions. And we worked on it. There were two of my partners and I, Emily, who I've mentioned, and Will Stransky. And yes, Jonathan came out with Crawford and Matt Law, and so there were six of us there the day that we pleaded the case. We were in a large courtroom. There was obviously a lot of interest. There were overflow rooms for reporters. But at the end of the day, it was like many other cases. Once you really worked it down, it was a pretty simple question. and it went our way.
You mentioned that this was an urgent proceeding. Can you talk about your urgent proceeding playbook? So, first of all, how urgent was it? How short of a notice was it? How quickly it unfolded? How quickly you had to put together a record and make your submissions? We really want to know more about your urgent commercial litigation playbook, at least the way you do it on the West Coast.
Yeah, well, we don't have a regular commercial list, and we don't in any formal way have specialization amongst our bench. But in informal ways, there are judges who tend to hear similar types of cases. And what we do is if you have a case and you don't abuse the privilege, but a case that has urgency and demands quick attention, you reach out to the trial coordinator, you reach out to the Chief Justice, you explain why it's urgent, and things do get accommodated when, in my experience, when necessary. This one was, I can't remember exactly, but it was a matter of a couple of weeks, I think, from the time we filed to the time we were arguing. No more than that. I've argued a case in the context of a takeover bid, minimum period of 35 days, where we were through the Court of Appeal from the filing of the writ in 21 days, and the court just got that accommodated. So it's a far more informal procedure, but as needs be, the court does find ways to get it done.
And you were entirely successful in this case, if I'm not mistaken.
Yeah, we were.
I want to talk now a little bit about your bio, and I really want to talk about your path and your litigation practice. First of all, where were you born? Where did you grow up?
I grew up in a little town in the interior of BC called Trail. And it's in the Kootenays, right along the American border. The year before I was born, as anyone from Trail will still tell you, they were the last amateur world hockey champions from Canada. It's there because it was smelter is still there, but it was at one time the biggest non-ferrous, non-iron smelter in the world, lead, zinc, all sorts of stuff. So it was an industrial town. My parents were from Vancouver, moved up there after my dad finished university, after he was in the RAF in World War II. And they never left, stayed there, raised their family. And then, I'm one of a number of brothers, and some of us left and some of us didn't, but my parents always stayed.
And what moved you to become a lawyer? Tell us more about your parents. Were they an influence on you at the time?
Oh, of course they were. I think I got a lawyer idea in my head when I was about 10 years old, that never shook, obviously. I don't know exactly why or where it came from. My parents were very thought education was the key to most things, if not all things. And so they were very, very for all of us going to university. My dad had been the first in his family to go to university. His father was a train engineer for the CPR. And my mom's father was a customs agent on the Alaska Panhandle, of all places. But they were focused on education. So you were going to go to school. What you wanted to do was up to you. But they were very, very much in favor of us all getting education and going from there.
I've heard from many guests of this show, judges, lawyers, what it's like to grow up in Toronto. At best, what it's like to grow up in the GTA. And you don't ask people who grow up in Toronto, what did you think about BC growing up? That's just, I guess, the way it is, that people who grow up here in Toronto, they don't really think about any other place very much. But I'm curious about this dynamic, the BC-Ontario dynamic. This is definitely a dynamic in Canada, and maybe we will expand later to see how it's reflected in law practice and so on. But When you were growing up in a small town in BC, did Ontario exist for you? Did Toronto exist for you? Or was it a completely different sort of universe?
Um, it existed. I had cousins in Montreal, so Montreal, and they used to come. My mom's brother worked in first for CP Air and then via rail, and they were constantly traveling. So Montreal was a place that we talked about and thought about, and most of our family were Montreal Canadian fans, and
Mhm.
Toronto was there, but it was far. Vancouver was the big city, and that was an 8 hour car drive away. So that was sort of the focus of your thinking when you were from a small town in the interior of BC.
You mentioned that urgent proceedings, at least this is how I understood it, are not really a very common thing in the courts where you practice. And I think you related that to the West Coast. Am I correct in understanding you, or am I wrong? And if yes, then please talk about this West Coast chill vibe and approach to things.
Well, I think it starts with the fact that Toronto is very much the economic center of the country, and so it throws up an awful lot more of those kinds of problems and cases. Um, the origin of the commercial list isn't something known to me. I associate it with Justice Farley. We are awaiting a new Chief Justice. Our prior Chief Justice was very much wanted his judge to be generalists. We've, of course, all been suffering from lack of appointments.
Mhm.
So, a combination of factors, amount of workflow, um, number of judges, philosophy of the Chief Justice have left us with a relatively generalist court. But that doesn't mean as the cases come along, it's not all right. Well, here's who's suitable for that, who's got the time. We've got to get this done, and so just a much more informal process for all those reasons.
I heard that BC courts, at least this is a rumor that I hear. I heard that BC courts are more efficient, have smaller backlog, and it's much easier to file in the BC Supreme Court, which is the equivalent of our Superior Court here in Ontario,
Mhm.
than here. Is that just a function of the different scale? After all, the population is much smaller in BC. And you mentioned that the pipeline is smaller because of the number of HQs in Toronto, for example. Or is there something in BC, something in the nature of that province and the bar and the profession there that facilitates more efficiency? For example, I interviewed Shannon Salter when she was chair of the Civil Resolution Tribunal, and that tribunal, of course, is a very different from small claims court in Ontario, and it came up with a lot of innovation in handling small claims. And that wasn't an aberration. I don't think it was an accident. I think it was by design. And in this respect, do you think it makes sense to say that BC has a different approach to litigation than Ontario um, uh, in substance, or is it just a matter of different scale that BC is more efficient?
Oh, well, I mean, I'm not, that's interesting. I'm not sure I'm with the premise that BC is more efficient. I think there are some, and we're talking about, a system of justice that has different parts. I should say, Shannon was an associate of mine when I
Oh,
practiced at
wow.
Ferris. I know Shannon started working as a summer student with one or two of our lawyers when she was about 16. So go well back with Shannon, and she's had just an incredible path. The CRT, yes, it's efficient. It's not beyond its own controversies and just sort of by way of process. But I don't know that if, you file we call them notices of civil claim out here now. You get a trial date. I don't know that it's much more efficient. I know it's very frustrating often to people from Ontario and Toronto that they'll get all ready for their trial and their chances of getting a judge might be 1 in 3 the first time you set it and you've prepared your trial and off it goes. I've had experiences on the commercial list of seeing things get done in months that would have taken us years. So there are different
Mhm.
pieces of different parts. Everybody's tackling uh, the same problems in different ways. Uh, so that's I guess an answer that starts with I think the premise that BC is more efficient. We had a big move for a commercial list about 10 years ago that just didn't get off the ground. But I think there is just less demand for a specialized court. Is one of the features of why it hasn't continued to be talked about. I would certainly like to see a few judges. I believe a bit more in specialization in the court. It's there informally. But in any event, I'll let you ask another question. I'm just not sure that I'd buy into BC's just more efficient across the board.
I agree with you that Toronto, well, yes, I guess Toronto is what I really know, has different tiers in our justice system. So the commercial list is incredibly efficient and accommodating. You mentioned your timelines with the Rogers case. I thought of the Cineplex case a few years ago on the commercial list, which went from filing to trial in 1 year, and it was a $1 billion claim by Cineplex against Cineworld, a UK company. Goodman's was on for the plaintiff, and McCarthy's on for the defendant. So that tier is really really well served and is quite efficient. Our civil list here, the regular civil list in the Superior Court, is in crisis, I guess, for lack of a better word. So now I'm perhaps relative to that, BC seems quite efficient. I also hear some word about the friendliness of British Columbia to class actions. Is that fair, or what is your take on that?
Yeah, I think the legislation has tilted a little bit to make BC. I'm not doing a lot of class action work these days. It's your career sort of goes through kind of streams and currents, and you get caught up. But I understand that yeah, the legislation has been tweaked such that it's a favorable filing jurisdiction for plaintiffs.
I want to talk about some of the accomplishments that you had, and I'm curious about them because I've heard those names and I heard those organizations, but I don't really know much about them. And it's interesting. I'm sure our audience of lawyers and judges will want to know. So, you are past president of the International Society of Barristers, and I believe you were the first non-American president of the organization. This is an American organization, I assume. Can you tell us more about the International Society of Barristers?
It's much like the American College, smaller. There are, I would guess, 40 or 50 Canadians, and a few spread elsewhere. But yes, the weight of the organization is definitely American. It's a sort of peer-reviewed, judicially supported candidates for membership group that really takes one convention a year. And the first thing you're told is that you wouldn't be here if we didn't think you were a good lawyer. So do not spend the week talking about how good a lawyer you are. You're here to have fun. And it has speakers of kind of all walks of life, bit of a Renaissance week. There's just enough law to get people their CPD credits. And it's just a very tight knit kind of cathartic week where you're meeting with old friends and seeing great speakers.
Another exclusive organization that you're a member of is the American College of Trial Lawyers, which I think you mentioned briefly. Can you talk about that organization a little bit?
Yeah, the college is a larger organization. It has more activities. Um, has more of a staff and is involved in promotional is the wrong word, but an advocacy group for the trial lawyer profession, much more. And a larger group. You mentioned Jonathan is a member. There are many out here. Yeah, larger organization, same idea, but a bit more law oriented in many ways than the International Society of Barristers, which is a let's spend a week together with a little bit of law and a lot of other stuff.
Yeah, I like the a lot of other stuff idea of the International Society of Barristers. You used a good word to describe it. I don't remember what it was, but it's good when lawyers show interest in something outside of the law and explore it together. It must be a really good week. What about that other organization that you're a fellow of, the International Academy of Trial Lawyers? Can you tell us more about that one?
Another similar organization, Brian Gover from Stockwood sponsored me into that, and I think Matt Gottlieb, Jonathan, there's several lawyers here. Everybody, all of those organizations are kind of looking for the same profiles, so you end up if you end up in one, you tend to end up in others.
Right. You have been involved with the rules of civil procedure in BC and with the Rules Revisions Committee in BC for a long time. How many years?
I was from, probably 1997 or 8 through 2014 or 15 when
Mhm.
the committee for a period was disbanded.
Why was it disbanded?
Well, it was there was
Did the
yeah.
rules achieve perfection in BC?
No, I don't think so. I mean, I'm known as someone who liked them more the way they were and thought that it turned from one volume that was about 2 inches thick into three volumes that were about the same thickness. We split the family rules from the civil rules. Yeah, I was involved in that for a long time. I don't know personally how many solutions lie in rules. It's about people doing their jobs well and better more than the rules. But yeah, I spent a long time on that committee as probably a bit of a naysayer for some of the things that were being promoted.
What is the number one thing you would change about the current rules of civil procedure in British Columbia?
Oh wow, that's a very interesting question.
I'm just preparing some inspiration for our own rules committee that is hard at work right now to rewrite the rules. They are working on a complete revision. Everything's going to change. So I'm sure they'll be watching this. Maybe you'll provide some inspiration from BC, the cross-jurisdictional experience.
Well, I mean, one thing that you'll that does come to mind, although it's sort of not a number one rule change, is I found, and I think a lot of the bar found after we did our big rewrite in 2008. We used to have précipes and we had to find a word for them, and the word was requisition, and we reordered them and renumbered them. And I can still cite to you the old BC rule numbers, and I don't know the new number. And so I have a table of concordance, and lots of people found that some of what happened was felt a bit gratuitous, and like there was a whole bunch of institutional knowledge, and learning a new language is always a time consuming thing, and of course time is precious and costly.
I'm wondering if BC looks at Ontario at all, whether in its case law or in designing or revising its rules. Is Ontario influential in BC, or is BC a completely standalone jurisdiction that doesn't really look at Ontario very much?
Oh, I think Ontario's looked at a lot, substantively, and in particular areas, certainly on the commercial law. And it's not that we don't have our own body of commercial law, but you know, I'll take an Ontario Court of Appeal case or a BC Court of Appeal case anytime. There are areas of law that, I would imagine family practitioners, because it comes off differently designed statutes, that it's probably less so. But yeah, the size and depth of Ontario in the practice necessarily makes it influential if you're trying to do the best job you can out here.
Will you see citations to Ontario cases in most submissions, or is it still, a rare site? Because in my experience in Toronto, I don't really see a lot of BC citations. I remember one Court of Appeal case in which I was acting for the respondent. The panel imported a case from BC. It imported a BC Court of Appeal case because there was no precedent on that issue in Ontario. So that was my only experience, if I remember correctly. But is your experience different? Do you see Ontario cases cited all the time, or it's still, a more or less rare occurrence?
I know it's more all the time than rare, for sure. Where it falls between those two, I don't know, is a matter of judgment. Part of it is, our job isn't find me a case that says it's tell me what the law is, and that necessarily entails deeper digging. Where's the bigger pool of consideration principle? So we end up with Ontario law cited frequently. You still, if there's a equivalent BC case on the subject, that's your starting point, of course.
I'm curious, so you've probably trained several generations of lawyers over your career. I'm really curious about your experience training other lawyers. How many lawyers have you trained approximately? What's the ballpark? And also, what is your ideal lawyer? Who are you training when you face a newly minted lawyer, junior lawyer? Who are you really training? Who are you preparing? What's your vision, and what are you preparing these lawyers for?
Well, let me attack that this way. I mean, I sometimes say to young lawyers, and you're in interviews and they're talking about mentoring, and I say, well, what do you mean by mentoring? And I turn it around and I say, I always thought, for me, mentoring was, as a young lawyer, finding the best lawyers you can and as many good lawyers as you can to work with as often as you can. And that being the key to it. That's one of those things that, as you say, currents and things are constantly in flux. How many lawyers you trained, as you start getting more senior, you start working with people that are more junior. There come to be more of them over time. Gosh, I had a hearing week a couple of months ago where I appeared in two judges who were former juniors of mine. You want to talk about a funny feeling? So I don't know. I mean, I think you have a lot to learn as well as the senior lawyer, and a lot of listening to do. And one of the very first lawyers I worked for was famous for making sure he told everybody that, and so it's a two-way street. But life is experiential, right? You just create experiences, expose to experiences, be as involved as you can. Try and keep everybody's expectations high. That sort of thing.
Can you talk about your own articling? Where did you article? What did you do for that?
I articled at a boutique called Doust and Smith. Len Doust was a very famous, he's still is a criminal lawyer in these parts, had a national reputation. And Ken Smith, he was the criminal side. There was a civil side that I articled to a fellow named Ken Smith, who great lawyer, great Court of Appeal judge. And we were 12 and had civil and criminal side. I did more civil, but I was a year called when we merged into a firm called Shrum Little that became part of McCarthy and McCarthy. And so 3 years out through the mergers, I was at McCarthy's for a couple of years. So I'd gone from this little boutique to the first national firm. So that was the path, and got exposure to more lawyers, and then moved on from there to a local full service firm called Ferris, where I stayed for about 17 years, working with the litigators there.
Yet another McCarthy's connection on this show and podcast, from a partner to the chair of McCarthy's, Sarit Batner. I've interviewed so many McCarthy's lawyers. Tell me how you came to write this book. And for those who are not on YouTube, for those who are listening to the podcast, I'm holding up a copy of Sapinka on the Trial of an Action. And the author's name is J. Kenneth McEwan, QC, KC now.
Yes, KC now. I was introduced to that project by Mark Gelowitz from Osler.
I know Mark.
Mark has the appellate
version,
book, and I actually was one of the very first BC members of the Advocate Society, which I came to through the Sapinka Cup. And I was president of the Sapinka Cup, and the society was involved in that, and got to know some of the people. But Mark, I had done a couple of cases with, and he said they're looking for someone to do an edition of this book, and so I said yes, and several years later, actually got it done.
Well, this is a very valuable hands-on practical guide to doing a trial. What is your trial, sort of big trial philosophy nowadays? Do you do a lot of trials more recently, or trials are becoming extinct even in your practice? What is your big bird's eye view of the trial in 2024, of the civil trial?
Oh, they're becoming not extinct, but rarer. There are all the pressures we all talk about, the cost pressures. My own view, and one of the lawyers I worked with, George McIntosh, has come back from the bench and joined me. I used to do large trials under him where he insisted you gave him 200 documents and no more, or he'd have a number, and he'd say you can distill anything down to what's really important. And so he drove that. That didn't mean that I didn't have my own set of 1,000 in case I got the wrong 200. But I think that I think it's getting harder and harder, and some of the things are just extraneous to us. I think the photocopier is the enemy of the law. We produce so much law now. Somewhere in there in the book, I didn't know you had it, but there's a little tagline to a chapter where Johnson of Johnson and Boswell in way back a few hundred years ago said that there's too many precedents to get to principle, and that was 200 or 300 years ago. And I think that's true. I think it's very hard to manage what we've unleashed with technology. I think it's very hard to become good at doing trials unless you've done some trials. I think we're loose on pleadings. I mean, there's all sorts of drivers to the problem, and it just. But one of the things is there's just not opportunity at a more junior level to get in as much as people should.
Could you elaborate on what you mean when you say we're loose on pleadings?
I think, and there's many drivers. I think that pleadings, you don't want to be overly technical, but we tend to run off of the pleadings, at least in BC, cases where there's an awful lot of evidence that needn't be led, shouldn't be led, is of marginal relevance, a little like we're running public inquiries. And I think one of the problems is just the length of trials. And it's interesting, you know, I mean, judges will tell you that, but judges were lawyers and so probably did all the same things. It's a hard thing to get containment on for lots of reasons, but I think if we really were just better at articulating what is actually an issue and the issue through our pleadings and then sticking to it, we'd do better. But you know, as I say, it's there are so many things that make it so complicated now to do that. You know, starting with the photocopier.
Right, and we don't even use the photocopier, I think, anymore because everything is electronic, and even in Ontario, we will show documents on a screen in the courtroom. I mean, I'm sure that some people still use books of documents, printed books of documents in the courtroom, but screens are really common now. A lot has changed, as you have witnessed yourself over the last 10, 20 years in this profession. Do you feel that the pace of change is accelerating? Do you think that changes will happen more frequently now and faster? Or do you think we're going to get stuck in a period of stability and things will really not move as fast anymore down the road?
Oh, I don't have any real predictive sense of that. I mean, I don't know where AI is going with what we do, and I haven't pretended to follow that very much. I think everybody sees the pace of change and the problems it creates, but it's, you know, the solutions are the terribly hard part. You know, I would like to see things like very well-funded law reform commissions. You know, their papers are valued. The American Restatement, we should rely more on textbooks rather than churning out, you know, the 4 or 5 books of authorities. There are things that could be, but I don't know. It's just hard. It's been hard. It's hard to imagine things standing still long enough or finding funding to do those kinds of things, right? So where we are is with the shortage of judges, and longer and longer trials and less training, and it seems like, you know, it's a tiger by the tail to try and get a handle on it.
Every year, thousands of young people go to law school. They probably have some hopes and aspirations or some ideas about their future profession. Every year, thousands graduate from law schools, join the profession. What is your message to these people? What do you want to tell them? They will hold the profession in their hands within just a few years.
Oh, well, I mean, I think I want to tell them that there's no, and sort of anybody in BC listening will say, well, there goes Ken. There's no substitute for hard work. And you know, it is a fiduciary task, right? I mean, you owe people your best. But it's a wonderful life. And it's the experiences are fantastic. It's intellectually challenging. It's often very funny. So, you know, if you have a passion for it, or if it's something that you really feel you want to do, just roll up your sleeves and it's well worth it. I really think that.
Ken McEwan, everyone. Thank you so much, Ken. This was a fascinating conversation.
Well, thanks for the invitation. I enjoyed it.